This is Left Voices for Monday, March 24th, 2014. I'm Andrea Sears. Tonight,
there's old cases where people sued claiming that they have a religious objection to the minimum wage, or they had a religious objection to paying Social Security taxes. There's a lot that can go wrong here if Hobby Lobby goes badly.
A Supreme Court case that could make discrimination a right. On Tuesday, the U.S. Supreme Court will hear arguments in a challenge to a provision of the Affordable Care Act that requires corporations to provide health insurance that includes coverage for contraception. The owners of Hobby Lobby, a chain of craft stores with more than 500 outlets, say that's unconstitutional because it violates their deeply held religious beliefs. But contraception may just be the tip of the iceberg. Arizona recently passed legislation that would have allowed businesses to discriminate against anyone who they claimed violated their religious beliefs, like refusing to rent a hall for a same-sex wedding reception, all in the name of religious freedom. That bill was vetoed by Governor Jan Brewer, but similar legislation is pending in several other states. Ian Millhiser, the justice editor at Think Progress, says in hearing the Hobby Lobby case, the Supreme Court is taking on two broad issues.
The first is whether corporations aren't just people, but whether they can actually be people of faith. So whether or not a corporation is allowed to claim many of the religious liberty rights that have historically only protected individuals, and I should say some nonprofit corporations. We're talking about for-profit corporations here. And then the second question, which I think is the biggest issue, is that the Supreme Court has recognized for years that essentially my religious liberty stops at your body. I'm not allowed to claim that because I hold a religious belief, that allows me to step on your legal rights. And this case challenges that. In this case, the issue is whether or not an employer, because they object to birth control, can deny birth control coverage to their employees. And if that principle is torn down, the principle that my religious liberty stops at your body, then it could lead to all kinds of things, from other cases where people don't want to cover health care to anti-gay discrimination. There's old cases where people sued claiming that they have a religious objection to the minimum wage, or they had a religious objection to paying Social Security taxes. There's a lot that can go wrong here if Hobby Lobby goes badly.
This really grows out in a way from a case that was in 1990, the Employment Division v. Smith case, in which Antonin Scalia actually wrote the majority opinion. In that case, it was people being fired for peyote use when it was part of their religious practice. Mm-hmm. So how did we end up back at this question?
The short version of it is that the Smith case that you mentioned contracted the scope of religious liberty in this country quite a bit. And so shortly after that decision was passed, Congress passed a law, it's called the Religious Freedom Restoration Act, that was intended to restore what the scope of Americans' religious freedom looked like on the day before Smith was decided. But it's important to understand what RFRA did not do. So what RFRA did is that it restored the notion that if I take peyote for sacramental reasons, or there's another case dealing with hallucinogenic tea, and I want to do that for sacramental reasons. There are also cases dealing with Jewish service members who want to wear yarmulkes, or Muslim prisoners who want to grow beards. All of these are typically cases where the person who has the religious faith isn't hurting anyone. If someone grows a beard, it doesn't impact anyone else. If someone wears a yarmulke, it doesn't impact anyone else. And generally, if someone takes sacramental peyote, it doesn't impact anyone else either. That's what makes these cases different than Hobby Lobby. In Hobby Lobby, the question is whether someone with a religious objection to following a law that benefits another person is allowed to decide that they don't want to follow the law. The question is whether or not they are allowed to use their religious faith to step on the rights of someone else. And the Supreme Court has never said that that's okay.
There was another case that you've cited in a couple of these articles was the U.S. v. Lee case in Pennsylvania that was an Amish farmer who did not pay into Social Security for employees on his farm who were also Amish. How does that play into this?
Lee, I think, is probably the most significant precedent at issue here. What Lee said is that when someone enters into the business space, they have to follow the same business regulations that every other business has to follow. Lee also warned that if you refuse to pay into the Social Security system for your employees, what you're essentially doing is imposing your religious beliefs on them to their detriment. And so the same rule that applied in Lee, Hobby Lobby is a business that's entered to the business space. You have to follow business regulations. That includes this birth control rule. It should not be allowed to impose its religious beliefs upon its employees. So the owners of Hobby Lobby shouldn't be able to say, we object to birth control, so we're going to deny coverage to our employees because of our personal religious beliefs. Lee is very on point with this. The only way that the Supreme Court could really rule in Hobby Lobby's favor here is to ignore what they said in the Lee case.
The case, as it's being argued in the Supreme Court, is actually based on a fallacy. Hobby Lobby is challenging birth control provisions that they say are tantamount to abortion, like Plan B, when in fact that's not how Plan B works at all. Do they have to be factual in their presentations? Would this be a grounds for the Supreme Court to throw out the entire case?
I mean, potentially in this case, although I'll note that there are plenty of people who object to birth control as birth control. So if the Supreme Court throws out Hobby Lobby's case, someone else is likely to come along who actually objects to birth control. Now, that said, yeah, it's really troubling that someone gets this claim that they not only get the law they want, they also get the facts that they want. If Hobby Lobby can claim that something that's not abortion is an abortion and then object to it on religious grounds, why can't they claim that someone's chemotherapy treatment is an abortion and say that they're not going to pay for that? I saw someone on Twitter joke, why can't they claim that someone's heart medication is an abortion and refuse to pay for that? The old joke is that we're entitled to our opinions, but we aren't entitled to our own facts, and Hobby Lobby really wants to have their own facts here.
Are they arguing in this case that they are simply talking about this one religious belief and this one law? Is there any way that a ruling in this case could be so narrow that it would not invite other attempts to gain exemption from federal law?
Well, Hobby Lobby, probably their strongest argument is that they argue that the birth control regulations already contain certain exemptions, and so they're claiming that if the government creates one exemption, they have to create a big exemption for all people who have religious objections to the law. It is a narrower ground than saying that anyone with any religious faith can get anything they want. But the problem with that argument is that it's ultimately going to be very destructive for people who care about religious liberty if Hobby Lobby wins on those grounds. Because if the government's not allowed to create narrow, very tailored exemptions when they feel like a religious sect is a particularly compelling claim, unless they want to create a big old exemption that lets anyone with an objection through, what that means is that the government's just not going to create any exemptions at all. There will be no more religious exemptions, even in cases where it's perfectly justified, because the government knows that once they create a small one, it blows the whole thing up. So some of Hobby Lobby's arguments here are actually very dangerous to people who care about religious liberty, because what they're doing is handing a roadmap to the government saying, whatever you do, don't create any religious exemptions ever again.
Ian Millhiser is the Justice Editor with Think Progress. This has been Left Voices for Monday, March 24th, 2014. You can help support this experiment in independent journalism by visiting our webpage at www.leftvoices.net and following the Ways to Support Left Voices link at the top of the page. Join us again tomorrow for more news and information from a progressive perspective. I'm Andrea Sears for leftvoices.net.